Welcome to this explainer. Today, we're diving into a really fascinating, incredibly high-stakes corner of South African law. We are going to look closely at a landmark constitutional court case on HIV treatment, specifically case CCT 8/02, and examine exactly how the highest court in the land handles late, unexpected interruptions. It is an absolutely brilliant study in how a justice system balances the endless desire for absolute truth against the urgent, pressing need for timely justice.
So, here is our agenda for today. First, we'll look at the landmark HIV case itself. Second, we'll define the concept of an Amicus Curiae. Third, we'll break down the professor's late challenge. Fourth, we'll examine the sanctuary's new evidence. And finally, we'll wrap up with the balance of justice.
All right, let's jump right into part one, a landmark HIV case, and the immense stakes of case CCT 8/02. To truly understand the court's strict rules in this scenario, you really have to understand the sheer weight of what was on their docket. This was an incredibly urgent, high-stakes matter fundamentally concerning the constitutional right to healthcare. At the very heart of it was the reduction of mother-to-child transmission of HIV using a drug called nevirapine. Lives were quite literally on the line here. Because the stakes were so incredibly high, the matter demanded urgent attention. And it's exactly that urgency that set the stage for the intense, strict procedural scrutiny the justices applied to anyone trying to join the case at the last minute. Moving on to part two, defining Amicus Curiae, or Friends of the Court. Now, you might be wondering, what exactly is an Amicus Curiae? Well, as a friend of the court, an amicus isn't actually a direct party to the lawsuit, but in return for the privilege of participating in the proceedings, they carry a very special duty. They must provide cogent, helpful submissions that don't just repeat arguments that have already been made. They have to bring new contentions to the table, and crucially, those contentions must be based strictly on data that is already before the court. The court's stance on this is brilliantly illustrated by the precedent set in the Fos case. It basically boils down to this. The underlying principles governing any amicus are usefulness and relevance. The court maintains absolute control to ensure these friends genuinely assist the justices, rather than, just bogging them down in irrelevant details or going off on tangents. Okay, that brings us to part three, the professor's late challenge and putting science on trial. So, the rules clearly state an amicus application has to be filed timelessly, specifically within 10 days after the leave to appeal is lodged. In this case, the appeal was lodged on January 8th. The 10-day deadline passed in a blink. Yet our first applicant, Professor Malongo, waited all the way until May 2nd to apply for admission. And get this, May 2nd was literally the morning of the very first day of the hearing. So what was so incredibly urgent that it warranted interrupting day one of a major trial? Well, the professor wanted to introduce a massive, entirely new scientific challenge regarding the clinical trials of nevirapine itself. But remember that golden rule for an amicus we just talked about? You have to rely on data already before the court. The professor was trying to put the very science of the drug on trial using entirely fresh, entirely untested evidence.
As you might guess, the court's response was incredibly swift. The application was flat out refused. The justices noted that it is ordinarily just inappropriate for an amicus to try and introduce new contentions based on fresh evidence. Allowing the professor to open up a completely new can of worms on the first day of a protractor hearing, that would have been totally disruptive and deeply prejudicial to the existing parties. It absolutely would have forced a postponement. And, as the court rightly pointed out, it is simply not in the interests of justice to let a belated, disruptive application delay a matter that requires urgent, life-saving attention. No way!
Let's look at a different scenario in part four, the sanctuary's new evidence, involving Cotlands Baby Sanctuary.
Cotlands presents a totally different but equally fascinating procedural puzzle. Unlike the professor, Cotlands Baby Sanctuary had actually followed the rules perfectly to get in. They were already duly admitted as an amicus under Rule 9. But once they were in the door, they attempted to use a completely different rule, Rule 30, to introduce new factual evidence about the exact, tragic circumstances in which HIV-positive children live and die.
Here's the catch. Rule 30 is incredibly strict. You can't just throw new facts onto the official record. To bring in new material, it must be common cause, completely incontrovertible, or official, easily verified data. The absolute golden rule here? Rule 30 has zero application if the facts are disputed.
If there's a genuine dispute, it automatically proves the facts aren't incontrovertible. And that is exactly where Cotlands hit a wall. The government, who was the appellant in this case, officially objected. They correctly pointed out that this highly emotional, very specific factual evidence about the living conditions of these vulnerable children might not actually be incontrovertible. Furthermore, because Cotlands made this specific application at such a late stage, the government argued they simply lacked the time to properly and effectively respond to it. Admitting it, they said, would severely prejudice their case.
Which brings us to our final section, Part 5. The balance of justice and exactly why the court said no.
Now, you might be asking yourself, looking at the Cotlands application, why on earth would the highest court in the land reject evidence about the tragic living conditions of children suffering from HIV? I mean, isn't a court supposed to seek out all the truth it can possibly find, especially when the issue is so profoundly human?
Well, the court delivered a very measured, careful verdict. They explicitly stated that they didn't think the Cotlands evidence was irrelevant. Actually, they admitted it might have been really useful in educating the court, but, and this is the absolute key here, they ruled that the existing record already contains sufficient evidence for them to understand the plight of children living with HIV and AIDS. To make a ruling on the core constitutional issues, they simply did not need further evidence of these living conditions. When we lay it out, we can see how this builds a logical, step-by-step barrier against procedural chaos. First, the court respectfully acknowledges the educational value of the new evidence. Second, they verified their current record was already completely sufficient. Third, they recognized that allowing this would open up unfair, tangential disputes so late in the game. And fourth, by doing all of this, they fiercely maintain their laser focus on the core question at hand, the constitutional right to healthcare. This entire episode with the Constitutional Court really leaves us with a provocative thought to take away. In high-stakes, life-or-death litigation, gathering every possible piece of sociological and scientific data sounds ideal, right? But the wheels of justice have to keep turning. So how do we balance that endless pursuit of absolute, comprehensive truth against the urgent, pressing need for a fair and timely resolution? The South African Constitutional Court showed us that sometimes preserving the fairness and speed of the legal process means having to firmly close the door on late arrivals, no matter how helpful or well-intentioned they might be.